Hello, everybody, and a warm welcome to this episode of the Indian Lawyer Legal Tips. Today's topic is going to be of great relevance to all those people who are either landlords or tenants. Understanding your right, either as a landlord or as a tenant, will safeguard you in protecting your own property. I am Sushila Varma, Chief Consultant at the firm, and today we bring to you the topic called Understanding Lease Agreements. Now let us understand the first thing. Why is a lease agreement important? In brief, a lease agreement is a binding contract between the landlord and the tenant, and it covers the terms and conditions under which the property is being leased or which the property is being taken. The agreement provides a legal framework that monitors or guides the relationship between the landlord and the tenant, thereby protecting the rights of both parties. Registration of lease agreements are compulsory at times, but if it is for a period of less than 1 year, it is not necessary. Now let us understand the benefits of a lease agreement. The first I would say would be that an agreement would provide legal protection to both the tenant as well as the landlord because it sets out the responsibilities and duties of both parties. It also prevents situations where there might be a conflict because the terms and conditions are clearly written out. Lease agreements have the advantage of giving the landlord an assurance that his property will be occupied for a specified period of time for a specified use, thereby giving him a certain sense of security. Whereas as far as the tenant is concerned, the tenant is secure because the landlord cannot make unlawful demands if there is an agreement specifying the terms and conditions. Additionally, both parties have a financial security. When I say financial security, the landlord is assured that he will be paid his rent at a particular period in the month, and the tenant knows that he has to pay a certain sum within a certain time frame. And once this is done, then he is free to continue living there till the next month comes along. Now, how does a lease agreement protect both the parties? I would say a lease agreement offers protection to the landlord and the tenant because it clearly defines the rights of both parties and, most importantly, the remedies, if any. It also safeguards the privacy of both parties, such as property access, inspection, tenant privacy, etc. Tenants also feel that there will be no unwarranted termination if there is a termination clause in the agreement which the landlord has to follow. Now the next question would be, is the lease agreed to be registered? As per Section 17 of the Registration Act 1908, all documents pertaining to immovable properties have to be registered. But this is not applicable for a lease agreement which is for 11 months or a period less than 1 year. However, if the lease agreement is for a period of more than 1 year, it is necessary that the property has to be registered, and the registration fee for the lease agreement is generally calculated as 1% of the annual lease amount. Now let us understand what are the implications if a lease agreement that is required to be registered is not registered. I would say the first would be that such a lease agreement will be invalid in law and cannot be used as evidence. Failure to pay the appropriate stamp duty may result in the lease agreement or whatever other instrument that is being made to be impounded by the government authority which administers oath. Now, once this particular document is impounded, then it is sent to the collector of stamps for determination of the proper stamp duty, and the stamp duty has to be paid with penalty as the collector of stamps will determine. Now, according to Section 23 of the Registration Act, any document must be presented within 4 months from the date of its creation. If it is done after this period, then the document will not be registered. Let us examine a few case laws pertaining to lease agreements which ought to have been registered but were not registered. There is a Supreme Court case called KB Saha and Sons versus Development Consultant Limited, a 2008 case in which a division bench of the Supreme Court clarified that unregistered documents cannot be admitted as evidence under Section 49 of the Registration Act. However, they can be utilized only for collateral purposes as outlined in the Act. Such collateral transactions must be distinct from those requiring registration and not involve immovable property exceeding a certain value. Additionally, if a document lacks registration, none of its terms can be admitted as evidence, and using it to prove a crucial clause would not constitute a collateral use. Again, in another Supreme Court judgment, Paul Rubber Industries versus Amit Chand Mitra, 2022, the Supreme Court held that an unregistered lease agreement cannot be presented as evidence to establish the nature of possession in a legal proceeding. Hence, dear viewers, you are cautioned that if you are taking a lease agreement of any property for more than 11 months, make it a point to ensure that you get it registered. Now coming to the next very important question. When can a landlord evict his tenant? A landlord can evict his tenant if the tenant fails to pay the rent exceeding 3 months beyond the due date. The tenant has sublet the property without informing the landlord or taking his written consent. The tenant uses the premises for an unlawful reason, which is against the terms of the agreement. The tenant's action causes the property to depreciate. The tenant has reached the termination date and yet he has not evicted the leased property. And the objectionable behavior of the tenant, which can be termed as nuisance or which prompts complaints from other tenants. Now, what is the procedure which the landlord has to follow? Naturally, the landlord has to begin by giving a legal notice, citing reasons as to why he wants to evict the particular tenant. Once a tenant is given a notice, the landlord generally has to give a time period of 30 days for clearing the property, in the failure of which the landlord has the option of going to the appropriate rent control authority and filing a case for eviction. However, if the property that has been leased out is leased for agricultural or manufacturing purposes, then it is mandatory that the landlord gives a notice giving the tenant a time period of 6 months to vacate the property. Now, another very important aspect of lease agreements is when can a tenant stop making payments of rent and it would deem to be a legal act. I would say that a tenant can withhold or stop making rent payments for some of the following reasons. That the rental property is not secure and has safety issues, that there are repeated breaches of the tenant's privacy by unauthorized entry of the landlord, if the landlord violates terms of the agreement such as failing to make the repairs that he or she has to make or pay the maintenance if some maintenance has to be paid. The contractual damages can be set off against any obligations of the tenant when he is making the payment of the rent, and the landlord harasses or discriminates upon the tenant because of religion, race, gender or inability. Now there is another aspect of leasing that one should be aware of. This is what is known as a license agreement. Now a license agreement does not give the tenant or the licensee the same type of rights as one would get under a lease agreement. What a license does is it grants a specific right to use the property for a temporary period without transfer of interest. It is revocable by the licensor even if it's against the wishes or the interest of the licensee. It typically involves a lower stamp duty and does not require registration. It can be terminated immediately upon a sale to a third party or death of the party. A written agreement is not necessarily required, and a license can be withdrawn without any notice. Let me discuss a case pertaining to licenses. Municipal Corporation of Delhi versus Pradeep Oil Corporation and another, a 2002 Delhi High Court case. In this case, the court laid emphasis on a very crucial distinction between a license and a lease. The court held a license does not confer any property interest. A lease constitutes the transfer of property rights. The court observed that licenses, whether personal or contractual, do not create any estate or interest in the related property for the licensee. Additionally, it highlighted that a licensee without a grant simply enables the licensor to enter the land and enjoy it without conferring any rights or interests on the tenant. Therefore, the court concluded that licensees do not have any possession rights in the property. Dear viewers, a dispute between a landlord and a tenant is a very common thing. I would therefore advise all people who are looking at taking a property on rent, or all landlords who want to give out their property on lease, to please consider the importance of having the terms and conditions documented in an agreement, which is generally called the lease agreement. This may cost a few pennies, but in the long run, it will save you from a lot of anxiety, especially if the tenant refuses to return the property. We have tried to give you a snapshot on the law pertaining to lease agreements. However, there would be several questions in the minds of the readers, and we would be very happy to answer them. You're welcome to address your questions on the comment box, and we shall revert. Dear viewers, thank you for your support in watching our videos week after week. This has enabled us to grow, and we can now proudly say that our subscriber base has increased substantially. We hope to bring to you more episodes week after week, and we request you that if you have found this useful, please like, share and subscribe. If you want to be notified, please press on the notification button. Thank you, and have a very happy New Year in 2025.